Anybody else have a comment on that? Go ahead, sir.
Yeah, I just have a question about no other feasible use. What does that mean if you're trying to run a business? I mean, does that mean if you can't do a crematorium, he can put up a produce stand? I mean, doesn't it matter what the applicant is intending to do with the business?
It does. I think that
where the feasible comes in. I mean,
yeah.
There's definitely other uses, but the intentions have to weigh into that as well.
Yeah, it's a very high bar to say you can't use it for any purpose.
Right. That doesn't make sense.
Yeah, I understand. I accept that. Anybody else want to comment, please? No? Go ahead, back there. Go ahead then.
I guess I should come on with the gentleman behind me that if the zoning was, someone had zoning, had a change from one classification to another, and then make this decision to build a structure. And then now it's actually tough to conform to what he wants to do. It's after the fact, unlike the single family Ryan case, who's trying to do everything he's working at. I don't know of anybody building anything in the township without coming forward prior to investing any money. You have to show your plans, get approval, and know what the zoning is before you do anything. So it seems like the township residents and the board are being asked to do it in reverse to make it satisfactory because he's already made his investment, which to me seems like a burden on the township and the residents, because that property certainly can be used for something else. I mean, going back many years when the area was founded, I mean, it was a dairy farm. And it was just, the city dairy was there. There's been a lot of different things there over, the past more than 100 years. So a prime piece of property on M13 with that type of a business is like an odd thing. And because it was odd, why was it not brought forward in advance? And I don't know anything about this gentleman, obviously, has experience that his structure was constructed during the evening. That would be totally out of the line of typical construction activities. So it does seem rather suspect. And perhaps this decision cannot be reached tonight because more research needs to be done into it. Personally, I believe one question I have on the structure would be is the odor control systems that were passed what would be going in. Where and how would that be controlled so that the residents living nearby are depending on which way winds are blowing, who might unfortunately have that influence as a negative influence on their parcels as well. I mean, from the outside it looks fine in that, but I think there could be some negative consequences that people are concerned about. So those would be some of my thoughts regarding the topic.
Thank you very much. Any other comments, please? Yes, sir.
More of a future concern that the thing on stuff goes tonight.
Could you speak up just a little louder?
I apologize. More of a future concern for it, this is how this goes tonight. If this is approved, what's to stop everyone from opening their own private business or, this is going to sound rude, but a crackpot idea, just because, I can't use my land the way I want to, even though I already have it set up. If someone wants to open a machine shop on the property that runs 24/7, no one will appreciate that, but if you're restricting you from doing that, there's a possibility of being approved already.
Keep in mind, we're struggling to come up with a definition of the term right now. We're not really dealing with the merits of the case yet. And they may decide after we come up with a definition they don't want to hear it tonight, maybe some other night. That'll be there. But let me comment just real quickly on this notion that the problem can't be created by the applicant. Okay? That is a given. I don't care if it's a use variance or any other kind of variance. It's not part of the definition that we're trying to arrive at. It's always a given. If the negative event is created by the applicant, there's no way in God's earth he's going to pass that muster. So that's just a given. I just want that to make that as a point. Any other comments? Yes, ma'am.
I just think that including something about the land not being able to be used for something that would be within the zoning that's current.
Very good, thank you very much. Yes, sir.
Attending the last one of this and being involved in the planning commission, it sounds like we're playing loosely with definitions and trying to come up with definitions. People have said the smell, the odors, whatever you want to call it. The way our ordinance reads now, if Mr. Dennis and his company wanted to put in an incinerator and burn garbage, it's an approved use. The guy is trying to put in something that, who knows if the EPA is going to approve it. We learned that sitting here as a planning commission for hours. But what brings my attention is what you just said, Chairperson, was the applicant can't bring the due harm to themselves. Anybody that buys a piece of property and then decides they want to build a pole barn or a deck or whatever, they bought that property knowing our ordinances. Instead of buying property in a different township that doesn't have the ordinances, brought that due harm on themselves, correct?
That's potentially correct, but not entirely.
Like I said,
they could buy property
previously-
with the intent to seek a change in the ordinance.
Correct.
Or seek a variance, and that's perfectly proper.
Yep.
I think we're talking about something more devious than that, when we're talking about the applicant actually creating the problem, disrespecting the ordinance, disrespecting,
And I did go down that rabbit hole too, and this is different, which the act takes it to a whole nother level of 405 voting. It's a use variance, not a building a pole barn on your property and asking for a variance. It's a use variance, and that what takes it to the next level into that gray area with the definition. But my opinion on the definition, so everybody has it, is someone buys a piece of property, you buy a piece of property and you're building a pole barn, and there is a 40 by 90 rock where you want to put your foundation, and you would ask for a variance to move it over 8 feet instead of 10, and you talk to your neighbor and you work around. That's different than what we're going through here tonight. Another one is with industrial property, if it was contaminated, he went to dig to put in footings or something like that, that would be out of his control. I hate to say it, but it's wrote on a vaguer level, and you've been down this rabbit hole too. But this one right here, I actually had to open up the book and Google and look, because I couldn't quite understand the voting procedure and the Michigan Zoning Enabling Act. So then you have to go down that rabbit hole, which is huge too. And then you go into one of our books, and you spend a day and a half trying to find out where it applies here. So it is a little different than the day-to-day variances that are granted because of the word use. And they do state in the zoning and enabling different, criteria like contaminated soil or property lines, but it is gray. And that's what he's asking for is we're kind of discussing it with the township and us to try to all come to the same page on it, but.
And not to correct, what you said before about the AR and having an incinerator, but that incinerator in AR is also a special use, so that would have to go through, the proper channels too, as far as getting voted.
anything further, gentlemen?
I would like to say too, the applicant is a successful businessman. He's got a dog food business that does very well, I imagine, because no one does that, and that's a huge niche. He knows business, and he's been through processes before, and he is creative, because that's a business, hands down. I don't doubt that one bit.
But knowing business, then you know the right way to do things, and you don't put the horse before the cart. You should have figured all this out and got all these permits and everything, permission to do such, and all the variances before you cause hardship on himself.
Very good. Yes, ma'am.
If he already runs a business on the property, would then that not be considered a hardship on him to not have the use permit because apparently he is...
It's a different business than the crematory.
And again, we're trying the definition right now. We're not really dealing with the merits of this request, okay? We haven't gotten that far yet. we gotta know where we sit with the definition before we can apply it going forward, so that's what we're trying to do. Any other comments on the definition issue? Anything further from the board?
Just not sure we can get to a specific definition sitting here today.
Well, let me see if I can help. Now, this is the point in time where I'm entertaining a motion, and I have a proposed motion. I'll share it with all of you.
I just want to make one more comment.
Sure.
With regards to the comment in the back, the applicant was under the initial understanding that incinerator and crematorium was the same thing, so was operating, believing that he could still do that in that zone. And so that's where he proceeded, that's where I believe he proceeded with the initial stuff, the initial plans. And then when it was determined at our last meeting that the definition of an incinerator is not the same as a crematorium is why we're here today. It creates an additional problem. So we went past that variance to a use variance, which is what we're doing now. So I'm just trying to address that question back, that he didn't necessarily create that on his own at that point, because he believed that what he was doing fell under the incinerator on our ordinance.
Again, it's still a special use.
Well, yeah, so that was the original, and now this is about use, yes.
But wouldn't his financial hardship be the building that he built that he now can't use because it doesn't fall under it and he doesn't get the variance, but he's the one that built it? Without
Sir, I appreciate your input, but we're kind of at a different stage right now. We're proposing a motion to see if we can come to some consensus, okay? We've had the discussion. In that regard, I'm proposing the following. I motion as follows. For purposes of the Cawthorn Township zoning ordinance, in the context of a request for a use variance, the term unnecessary hardship, which an applicant must by law demonstrate for the granting of such a variance, be defined as a situation where compliance with the ordinance deprives the owner of the reasonable economic use of the land. That's my suggestion. My motion. And then open to discussion by the board if you like. Additions, subtractions, thoughts?
I guess when you come to the word reasonable economic use of the land, there could be many uses that it could be used for. So to say he can, somebody can have one thing and that's the only thing. So reasonable economic use kind of puts it into a vague.
Well, I think what has to happen, once you determine the definitions, then it's incumbent on the applicant to come forward with the necessary evidence and support to show that. And there may be different ways in which to establish that, but it'll be up to the applicant. But what I tried to do with this particular proposal is to kind of find some middle ground as opposed to the two definitions that I came up with in my search. One being very, very harsh, and the other being, in my view, a little more reasonable. And I think economics is the key when you're talking about hardship. But again, it's going to be up to the proof.
Would it be opposed to economic use of the land within the township ordinances? Because as I-1, he's got plenty of options to have a business in I-1 and produce economic growth.
Well, again, remember, we're just talking definition
Yes.
of the term, two words. And then once that's determined, then it's upon the applicant to come forward and show with some definitive evidence that, in fact, there is an economic issue here, and that it is a hardship, what it is and how bad a hardship it is. And then it's going to be up to the board, considering such, to decide whether that meets the criteria or not. But it gives guidance to the applicants going now and going forward as to what the ground rules are, what they have to come up with. Any other comments? have a second?
Second.
All right, roll call vote then.
Knight,
Yes.
Bott,
Yes.
Winnie,
Yes.
Wood,
Yes.
Whalen, yes.
Very good. We now have a definition. Gentlemen, I'll leave it up to you. You can take whatever time you need. If you decide you want to come forward at another meeting, I don't have a problem with that. I know that it's been a surprise to you. Our ordinance allows that. 902 allows us to adjourn to another meeting. I will tell you right now, that other date is July 30th. That's the next time we're scheduled for meeting.
I think we're going to proceed
Okay.
in light of the definition, and I appreciate, obviously, some thoughtful consideration just to the definition, which I appreciate. But I have some observations. First of all, we submitted this request April 17th. There's been at least one meeting and 2 other variance requests that have happened since then, and no definition was entertained or even discussed at that point. Mr. Knight, you prepared one, obviously took some time in preparation for tonight, and that was not something that was shared with us. And I understand why it wasn't agreed upon by the board, but the point is, of course, anyone that comes before this board or any other board should know in advance, these are the rules of the game. The other thing is, and if I can just ask you to circulate those, these are minutes from February 19, 2026, where there was another use variance application, and the meeting was called at 7 o'clock, and it was adjourned at 7:08. I think we've been here longer than that, and there was no discussion for this applicant. This is the road commission. There's no discussion about what's the standard to consider. The variance was simply granted in 8 minutes' time. So, I just think that's important. I would ask that these minutes be included with tonight's packet, because it gives some indication, at least to Mr. Dennis, and I hope you can appreciate his concerns that here we are tonight, and I will tell you, it took some convincing on my part. I had to essentially nag the township attorney, when are we going to be heard for our variance request, submitted in April, and here we are. So while I appreciate the fact that we can adjourn, Mr. Dennis has been antsy to get moving, and so we're going to proceed tonight. What he's asking for, of course, is to operate a crematorium on his property. And I think it's important to the board and to the audience to understand exactly what it is that he hopes to do if you granted that, because I've heard other meetings, and I think there's just a misunderstanding on that point. It's a single-use crematorium. We often see these things paired up with funeral homes, or some other mortuary science of business. That isn't what he's planning to do. This isn't a funeral home, it's simply crematorium. There will be the only employees, minimal employees, are needed for this use. As you can imagine, you don't need someone sitting there if you've got no business. So the only employees that are going to be on site are those individuals that are there to conduct the particular service that needs to be done. So the employees are not going to be creating parking problems at all. Because he's providing a service on referral from funeral homes, this is important. This isn't going to be a shop or a showroom where people just come in and meet with him and make arrangements for crematory services. Folks who lose a loved one go to a funeral home. Once they make the arrangements with the funeral home, they send that family to Mr. Dennis. And then the body is simply transported from the hospital or the funeral home to the crematorium, where it is incinerated And the only time that anybody from the public should be going to this location is to pick up the urn of ashes. So again, this isn't 50 people showing up shopping or spending time. This is probably someone stopping by maybe once a day, picking up the urn and leaving. Again, there should be no parking concerns whatsoever. The use is taking place entirely indoors. This is what, I find it interesting, your zoning ordinance says an incinerator is allowed in this area, not a crematorium. And now, we think those two things are essentially the same, but they're different in a critical sense. An incinerator can be out in the open, just like this, whereas a crematorium is all indoors. So if it's outdoors with an incinerator, with industrial uses, there's going to simply be environmental impacts that are not going to be present with something taking place entirely indoors. I've heard some members of the audience talk about, maybe you should go get your permits, maybe, we're concerned about air quality, odors, and things of those sort. Valid concerns. I think it's important for everyone to understand that if you grant him the use variance, he cannot open up tomorrow and start operating. He has to get permits from the state and local and trade association organizations, several. For example, he's got to apply for a cremation certificate from the National Funeral Directors Association, a trade organization. He has to go to MDOT to get a curb approach expansion. He has to get cremation services bond from the state of Michigan. Eagle has to evaluate his request and see if it complies with the Clean Air Act. So individuals here who are concerned about, what's going on in the air, well, Eagle is going to evaluate that and give him a permit or not. He has to get a license from MDHHS to handle deceased bodies as well. So again, you give him this tonight, assuming you do, he cannot operate. He has to go through all of those steps and satisfy others about the operational impacts before he can open this thing up. Your ordinance, a little bit out of order. I told you that our concerns with coming up with this definition on the fly here tonight. I submitted our application and I addressed the standards that were in your ordinance at that time. Self-created hardship was not one of those standards. Whether it was self-created is not one of those standards. And it isn't created in this case. What Mr. Dennis did before he did anything else is he came to the township. For those individuals who say this is an individual who went rogue, he went to the township, explained what it was that he wanted. The zoning administrator at the time said, you know what, I think you're an incinerator. So submit your paperwork as an incinerator. That's precisely what this man did. He followed the direction of the township when he came in and asked. I don't think that was bad advice. I think an incinerator is a crematorium. You need an incinerator for it. But again, the critical difference is that an incinerator is outdoors, a crematorium is indoors. This is not self-created because he did what the township asked him to do. We were before you several months ago. We were asking that you interpret your zoning ordinance to say an incinerator and a crematorium are essentially the same thing. This body disagreed. And that creates the difficulty. I think it's a practical difficulty, not an unnecessary hardship. That creates the practical difficulty with him proceeding. So we're here, we're happy to answer any questions, and Mr. Dennis may have additional things to say, but I'm happy to answer any questions that you have.
Let me ask a couple of other. When I look at the overall township, it seems to me, maybe I'm wrong, but vast majority of our zoning district is agriculture, as opposed to anything else. And I guess I wonder why this piece of property? Why not all the other vast area where the crematorium is allowed?
You know, I don't know that, but I'll answer it in this way. If he did nothing, if he went out of business and moved down to Florida, an incinerator is allowed on this piece of property. The
With special
township.
use.
I'm sorry?
With special use.
Understood. And I'm not saying he's out of the woods, right? I said that there's a lot of things that he has to do to satisfy it. But it is an allowable use. The township made that decision, that an incinerator is allowed in this district.
What was the original, what was the idea, or why was the zoning changed from agriculture to industrial?
Mr. Dennis, I'm
The
not...
whole reason I moved up there was for business, manufacturer. So I was going to buy a light industrial parcel somewhere. And when I first came here, Mr. Bragel was the supervisor. He sold me on the area. I said, all right, well, I'm not going to commit to anything. I'm not going to purchase land unless I know that I can have light industrial. We looked at their zoning map. He says, yeah, it would fit. I understand that it was spot zone, but in the same regard, there's a lot of spot zones. And even all the farmland that's surrounding me is zoned as R1. It's not AR. So, like, I get it. There's a lot of issues that lie in the ordinance that need to be fixed, but, you know, I'm not trying to create something unnecessary. You know what I mean? Like,
Right, could it be parceled off and rezoned? When was your idea to build a crematorium?
2018.
So when you
Prior
purchased
to me
land,
moving up here, yes, you guys wanted, you know, we had cannabis licenses available. That was one issue, or that was one thing I was looking for in light industrial. When you guys go back and I said, I'm not going to purchase it unless it's light industrial. It says, we'll change the zoning. We had a hearing. It says, we'll change the zoning. I said, all right, I'll buy the land. I would be one of your neighbors. I would be one of your community members.
so the zoning currently works with one of your businesses, but it's in contradiction with potential special use for...
I mean, if it was in, I don't know, I'm gonna throw a number out there, 70, 80% of other communities, crematoriums aren't light industrial because of their application, because of their use and their effect on the environment. It's where they belong. And I know I had a recording from the planning commission meeting on April 9th, where they were discussing it. They don't want to amend the ordinance. That was another opportunity where they said, you know, Mr. Wright, zoning administrator for 30 years, he suggested to amend it. He says, this is where it belongs. If you guys do a Google search, crematoriums belong in light industrial.
So you did your research before you came up here by talking to the township, found out what you needed to do to rezone it so that you could have your current business, and that it would also, most likely, of what you were told, allow for this additional business. So I'm saying you changed the zoning so that you were able to run your current existing business. And you were under the impression that at that time you were told that that would also allow you to run an incinerator business there.
You know, I think we're getting a little far afield here. You're talking about a lot of equities that may or may not have taken place over time, and how you were or were not treated at various stages. Our focus here tonight is really to address the request for a use variance in a very narrow situation. We're not here to consider what happened in the past. That's not our goal. We really don't have authority to do anything about that. We have to address what's in front of us. But let me ask you this. Can you comment on being deprived of the reasonable economic use as our definition now requires?
No, I can't. I can't. I could try to make something up on the fly, but no, that is a definition that was given us just moments ago, and I'm not prepared to speak to it. I don't believe that is the proper definition, but I respect the fact that this board accepted it.
Well, again, I would pose to you, do you want an adjournment to be able to ponder that and consider that.
No, again, he came here last fall looking to put this use in. This was submitted in April, Mr. Knight, and here we are. So as difficult as that puts a position us in, we're going to take a decision up or down tonight based upon that definition.
Okay.
I'd like to state, I was at the Bay County building meeting. The ground wasn't broke on that yet. We had 19 pages of current plans that we could look at our free will 3 weeks before the meeting, current written plans. They had a engineer come to the meeting, and what the difference was is that wasn't a commercial business, that was for Bay County use, not for profit, but to save money to clean the trucks before they dilapidated, to extend their life. So it helped our residents have less taxable value put into vehicles every year, every 10 years. We're hoping to get 15 or 20 out of it. Also, our zoning guy, which you guys both know, Tom Reif at the time, even implied, I don't know why we're here for this if it's not for public use. He says, but if you're checking the box, we checked the box and we went through the process. That's also why it was at 8 minutes. Is they had all the information and all the questions answered from both, even with our zoning administrator at the time. Second of all, you said yourself, the previous meeting that you keep resorting back to, you guys asked for an interpretation, not a variance at the time. You wanted an interpretation of the wording, so you could then in turn take it to the next level. So that wasn't really a holdup on our part. We gave you an interpretation of the meeting, and we talked it out and involved the citizens that were available and heard everybody talk. We went through the process. But to compare Bay Counties, it's apples and oranges or carburetors and potatoes. It's a completely different situation.
And if I can speak to that, are you holding them to the same standard that you're holding us? In other words, you're saying that we have to show that compliance with the ordinance deprives the owner of the reasonable economic use of the land. So if Bay County couldn't put in a wash bay, would that deprive them the reasonable use of their land?
Let me interject. That was not a use request. That was more an interpretation. In fact, as Brian has indicated, it was discussed at the meeting that why are you even here? What you're proposing to do is not prohibited. And then it was pointed out, well, wait a minute, the ordinance does address a car wash. And the conclusion that was reached is that only applied to a public situation, not someone privately having a wash for their own use. So it really was more straighten out the definition. It was not, I submit to you, a use variance.
And I hear you. I can only go by the minutes of your meeting, which are the official record. And the records indicate that they were before you on a variance, and there's no mention made about interpretation, a motion made to pass the use variance 8 minutes later.
Thank you.
Any further questions, gentlemen? Public comment on this issue now that we're at the, anybody have anything more they want to add? Doesn't appear to be. We don't have the zoning administrator, of course, is here, but I don't know if you have any input on this one or
I
not.
have no input on this
Okay.
matter at this time.
I understand.
I didn't see the files. There's a lot of paperwork that was over this.
I understand. Okay. But we don't have a representative of the township. The lawyer is not here, so we can't have any input there. No further public input, for sure? Last chance? Okay. All right. Any additional board comments this evening? I see none. At this time, the board will entertain motions. Does anyone have a motion they'd like to present?
I will make a motion motion that we deny.
I'm sorry.
I will make, you're gonna
I
have to.
know,
wait
they're gonna
for-
pull out real quick, sorry guys. Oh, they're taking the other thing. We're safe.
Go ahead, I'm sorry.
I will make a motion that we deny the variance of use, special use, or the variance of use variance, due to the fact that, this was denied in the past, for one, and because it doesn't meet the zoning ordinance, and because the public had spoken out in the past, as well as here, and, just the, and not that, because the public, we work with the public, we're here for the public, because it does not meet the specifications for the zoning that, we deny. Not that, should I?
No,
Should I make that more brief?
The motion is to deny the request, I understand. And I will support that.
Roll call vote.
Yes, sir, please.
Woods,
Yes.
28,
Abstain.
Bach, Knight,
Yes, I support the motion.
Whalen, yes.
Could you read those out loud, please? The results?
I'm sorry, what was your vote? Yes? So we got,
Knight is a yes, Bach is a yes, Wendy A is abstaining, Woods is a yes, Whalen is a yes.
okay, so we got 4 out of the 5. So it's denied. Okay. That, ladies and gentlemen, concludes tonight's event. Thank you all for coming, appreciate your time.